F4-523. I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid on its face.
To be addressed, that would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further, in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given.
Buckle up, guys. Today we've got Daniel Mkuu stepping up to challenge Eric Martin for the title of dumbest sovereign citizen alive. From the first seconds, Mkuu tries to bulldoze the court with legal jargon and demands for dismissal. But Judge Simpson isn't here to play. The tension builds instantly as the judge slams the brakes on his plan. You can already tell this won't end well for Mkuu.
There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. Mkuu, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all video discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. Mkuu, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him.
I expect that you would have them early next week. So if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th, and then he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Mkuu, starting in case ending in 09.
All right, guys, here's where Mkuu starts flexing his law degree from YouTube. He's dissecting statutes, tossing around Fourth Amendment buzzwords, and challenging the prosecutor to prove every element. The judge listens just long enough before firmly parking this for the prelim. You can almost see the steam coming out of Mkuu's ears. This is not the victory he was expecting.
Registered vehicle, which is a misdemeanor, punishable by up to 90 days, operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs.
Now things get interesting. Mkuu tries the speedy trial card, thinking it'll force the court's hand. But with missing video evidence and officers absent, the judge sticks to the calendar. And then, bam, the full weight of Mkuu's charges gets laid out. From eluding police to unregistered vehicle to DUI with prior offenses, this is starting to look like a legal avalanche.
Mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody or escape from lawful custody, excuse me. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. Mr. McGrew, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do, I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
McGrew, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now.
And here's the plot twist. After countless defiant hearings, Mkuu suddenly asks for legal assistance. The judge, visibly amused, reminds him of the perils of self-representation. This is the first truly smart move Mkuu's made, but it comes after months of digging himself deeper. It's a rare moment of common sense in a sea of sovereign nonsense.
These two cases now become public defender cases.
Thank you, Judge Torsia, Fleeser, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
He's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen. And procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that
Strap in, because here's where Mkuu drops the 390-day delay bomb, citing case law like he's on Law and Order. He demands dismissal, claiming due process violations, and pushes for release on personal bond. The judge counters with the reality. This isn't a petty misdemeanor, it's a felony-enhanced DUI. Mkuu's freedom isn't just unlikely, it's a long shot.
In response from the people regarding his bond.
People would ask the bond to continue, and I believe he also, I'm sure, failed to appear before the judge's place. So
Yes.
that warrant would also hold up with respect to the other comment. I'll wait. There are pleadings filed by the defender's office. Our office will respond to that. And I guess my one remaining point would be, should with the court's appointment Eastern the Public Defender's Office, I will make sure that the digital discovery that I referenced is served on the Defender's Office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied, so.
That's what I
would
Mr. Choda said.
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating one.
Here comes the bond battle. Mkuu wants out, but the judge isn't buying it. With an escape charge on his record, history of fleeing, and DUI allegations, the court labels him a flight risk and danger to the public. You can feel the gavel drop in that denial, and Mkuu knows he's stuck.
My bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or custody of.
I was dropped off at the hospital and they later tacked on
And
charges,
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out, and that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not said. August 19th, 2025, 12 noon. That is before me. On that date. For both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
This is pure SOVCI to theater. The judge reveals Mkuu has sued him and other officials, likely hoping to force them off his case. But Judge Simpson calls it exactly what it is: manipulation. No recusal, no delay, just business as usual. Mkuu's gambit fails, and the court keeps rolling.
Read through the complaint to determine whether or not it would on its face create a conflict with the court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I would deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there. They will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So.
I'm aware of such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case until I hear otherwise from the elected prosecutor.
Can I speak on that note, Your Honor?
I will let you talk, but I'm not.
We close with Mku's last desperate play, a change of venue. The judge denies it without hesitation, sealing the day's defeats for Mku. From start to finish, every legal move backfired. Make sure you hit that like button, subscribe for more courtroom chaos, and we'll see you in the next video.
Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very